there were three fairly recent cases by the Supreme Court that signaled perhaps greater invigoration in the takings clause area. The first arose in a case called Lucas versus South Carolina Coastal Council, and in that case, the government, in order to preserve these very sensitive lands that were adjoined the ocean, these barrier islands, basically said that with respect to certain of this property, it's so delicate and so necessary to preserve the delicate beaches there that you couldn't have any development on it. Now, this wasn't a physical appropriation, it was just a regulation, but the question was whether, nevertheless, it was a taking, and the court said, in that case, if the government denies you all economic use of your land, unless your use of the land that they're denying you is a nuisance or violates criminal uses or something like that, if the government denies you all economic use of your land, that is a taking. That equals a taking. And if the government does that, then they have to pay you for it. So it pretty much announced, with modest qualifications, a per se rule. Now, there were two other cases, and one is Nolan versus California Coastal Commission, and the other is Dolan versus the City of Tigard. These cases were slightly different. This wasn't just regulating all economic use, which now we're told from Lucas equals a taking. These cases involved a situation where landowners wanted to get government permits to develop their land in some way. They wanted to either knock down a building and put up a new building or expand their building, and they had to get permission under the zoning laws. And what the governments were doing in these cases, and they've done in lots and lots of other cases, is the government would condition the granting of the permit on the landowner ceding some portion of the property for either public use or something like that. Now, in Nolan, what was happening is the owner had a beachfront property, and they wanted to knock that down and build a newer, better house. And as a condition of giving them that permit, the government wanted to say, okay, we'll give you your permit, but you have to cede us a piece of property across your property, an easement, so that people could travel from one side of your property to the other along the beach. And the court said, no. This had nothing to do, this easement, letting people walk across this person's property, with legitimate zoning interests. It had nothing to do with, the sight lines to the beach or any other it was just something that the government thought, well, gee, this is something we'd like, and so we might as well get it now because you're seeking a permit. The other case, the Dolan case, involved a hardware store where a woman wanted to pave her gravel driveway and expand the hardware store. But in order to give the permit to do that, the government said, oh, well, you have to take a portion of your land near a creek and make that an undeveloped space and open it to the public as a greenway. And you also have to give us another strip of land and dedicate it to use as a bicycle or pedestrian pathway. Now, the government wasn't taking title to this, just you couldn't exclude people, you had to let them use it in these ways. The court said no there, too. And when the court said no there, it said, look, there's a test we applied to these conditions. First, the government has to prove that there is an essential nexus or link between the condition and a legitimate zoning interest. And second, the government, it has the burden here, has to prove that there's some rough proportionality between the condition that it's imposing and the fact that it's making up for the impact of the development. The test wasn't satisfied in Dolan, because although there was a need, an essential nexus between legitimate zoning interest and the greenway and the bicycle path, because the greenway was to help prevent flooding and the bicycle path was to help ease congestion, the court said that the government, and it put the burden of proof on the government, which is a new way of doing this, didn't prove with particularity that these conditions were precisely the ones that were needed to make up for the impact that the development would cause. Maybe you do need a greenway, but you don't have to open it to the public. Maybe you do need a bicycle and pedestrian pathway, but you haven't shown us the proof of how this will ease parking and whether people will use it, etc. You have to make the case before you can impose these conditions. Now, these are new heightened kind of tests applied in narrow areas, it's true, but they're important. Now, in the punitive damages area, the court has pretty much stayed away, until recently, from imposing limits on punitive damages. But in the case just decided in the 95-96 term, BMW of North America versus Gore, the court struck down an Alabama courts award of $2 million in punitive damages against the BMW franchise because it didn't disclose to a buyer buying a new BMW that cost $40,000 that it was really subject to a secondary paint job, that it had been used and had a paint job over it. The court said that this is way out of proportion and that due process does impose a limit. And it suggested three factors to judge whether a punitive damage award is appropriate or not. First, you look at the degree of reprehensibility of the defendant's conduct. Here it was purely economic, no health and safety issues. You also look at excessiveness in terms of the ratio between the plaintiff's compensatory damages and the amount of punitive damages. Here it was something like 500 times the actual damages. And third, you look at the difference between the punitive award and any civil or criminal sanction that could have been imposed for comparable misconduct. And in those circumstances, it can be unreasonable, and the court has so held. Now, the point about these two cases is that if you're grappling with a question relating to economic or property rights, you know the general rule under economic substantive due process. It's really a weak test, rational basis. But be sensitive, okay, to your context. If it turns out that the economic or property interest arises in the context of a punitive damage award or zoning laws or permit conditions, as I've described, then you may have something more to go on. So just make a sort of a footnote about that. If you have an economic, contractual, sort of ordinary social regulation, pretty much rational basis, and the government's going to win. But if you have, the government is going to win in almost all cases because they're going to have a rational basis. But if you have one of these little side areas, think about the rules I've just described. Okay, I now want to move along to different kinds of substantive due process rights. The court got out of the business of finding fundamental rights in the due process clause when Lochner was swept aside, when economic substantive due process was swept aside. But it didn't mean the end of that kind of behavior. And we saw again, reading fundamental rights into the Constitution emerge, but now in a different area, in the area of personal rights. Now, sometimes this area is referred to as fundamental rights of privacy, but that's a poor name because it tends to suggest that a lot more is encompassed here than it actually is. But it is a new discovery of fundamental rights under due process of law in the area of personal or privacy-type rights, and that's where that name tends to come from. So how did this start? Well, this really gets underway with a case called Griswold versus Connecticut in the 1960s. In Griswold, the court had to consider the constitutionality of a ban by Connecticut on the use of contraceptives. And in that case, especially since it was fairly soon after the rejection of economic substantive due process, soon after the bad odor of those cases, and the notion that it was illegitimate for the court to go about discovering and announcing unwritten rights and applying stringent tests to protect them, the court really didn't want to rely on substantive due process. Yet it had this, feeling, I guess, among a majority of the justices, that the government ought not be able to interfere with this kind of activity. And so, in the opinion for the court, Justice Douglas said that he didn't say we're relying on substantive due process. He said that we're relying instead on emanations or penumbras from a variety of the protections of the Bill of Rights. And from those penumbras, from those sort of emanations, those mists, if you will, of the Bill of Rights, Douglas said, we find that there's a fundamental right, the right to marry and the marriage relationship, and prohibiting the use of contraceptives, and the specter of the state enforcing that in the marital bedroom violated a fundamental right. Now, it was pretty clear in Griswold that the court was announcing something new. Something new was underway. There was new vigor in what the court was saying. It was applying a kind of substantive due process, even though it didn't call it that. It found a new unwritten constitutional right of personal liberty that it felt it could protect against legislative intrusion. Now, before we look further at what additional rights the court has included,